Good morning, team. Good morning, team. Good morning, team. I'm just confirming on sound check. If anybody can hear me, I would appreciate if you could just type in the chat box. Once again, good morning and welcome. Let's just give a few minutes for the webinar to start. Good morning, everybody. Thank you very much for joining this webinar this morning. We are quite excited to have you here. If you're joining us for the first time, my name is Wandera Kweyu, but everybody that knows me calls me Wandi. This is our first inaugural webinar for the year 2023, and we are very excited to have you here. As it is exactly 9 o'clock, allow us to give the other attendees at least about 5 minutes before we get into the conversation. Feel free to always like and follow us on all our socials. That is Twitter, Instagram, LinkedIn, and Facebook at Conversations with Wendy. You could always just type your question if you have one in the chat box, or you can type your question in the question and answer session and I will get back to you. So again, thank you very much. Feel very welcome. We started 5 minutes past the hour. Thank you. Ladies and gentlemen, once again, thank you very much for joining Conversations with Wendy. We are giving our participants another 2 minutes before we begin. Should you have any question whatsoever, just type it on the chat box. If you can hear me again, please just type it on the chat box so that we can know we are with you. Remember to like and follow us on our socials. That's LinkedIn, Twitter, Facebook, Instagram at Conversations with Wendy. We're very excited to have you here, and it is 1 minute to the 1 minute past 4 minutes past 9, my apologies, as we wait for our participants before we begin. For any questions whatsoever, just type it on the chat box, or you can type it in the question and answer session. Feel very welcome. We're very excited to have you here. Ladies and gentlemen, once again, thank you very much for joining us. It's just 5 minutes past the hour, and we are going to begin. For those that is their first time to join us, my name is Wandera Kwei, but everybody that knows me calls me Wendy, and this is Conversations with Wendy, our first webinar for the year 2023. We always have these webinars on each last Friday of every month. And we look forward to continuously having you within our sessions as we continue. Thank you once again very much for joining us. I'm very excited to have you this morning, and let us get down into it on the benefits that are payable upon employee separation. Before we get into fuller details, please remember to like and follow us on our socials. That's Instagram, Facebook, Twitter, and also we are on YouTube at Conversations with Wendy. Again, thank you very much for joining us, and let's just get straight into it. Now, when it comes to employee separation, it is important to recognize that employee separation is a very tense period during an employment life cycle. Sometimes the termination of employment or the separation from employment happens voluntarily, and sometimes it happens involuntarily, depending on which side of the divide you're standing on. Now, when a person is leaving employment or an employer is losing an employee, there is generally a very tense situation going on there, and it helps if, for instance, we can ensure that the people that are in the business or the people that are leaving the business, they leave knowing that they have left in good terms and that everything that they are owed upon their separation is paid, among other things. And that's why, for me, this particular conversation is literally very important, because it is one of the steps that starts us towards employer branding and continues to keep the brand that you have as an employer consistently, and also the brand that you hold as an employee going forward. Now, let's just start to talk about the different types of separation as we go into the details of it all. Now, separation, like I have said, is either voluntary or involuntary. Where we are saying it is voluntary, this is when the employee is in control of the separation. So you would find these kinds of separation are mainly in the areas of resignation and in the areas where a mutual agreement has been reached between an employer and an employee to terminate a contract. Now, the mutual agreement is something very tricky, but I will talk about it as we are continuing, but it is a recognized method of ending a contract. Second type of separation comes when the separation is voluntary. This is mainly when it is not in the control of the employee. Now, what do I mean by this? This just simply means that the employee did not want, at the moment of separation, the employee did not want to leave employment at that particular point. And sometimes even the involuntary separation is so involuntary to the extent that there are some situations where the employer themselves did not want the employee to leave their employer. Now, this occurs when a contract lapses, but legally you will hear people say a fraction of time. Just know that we are saying the contract has ended in simple terms. Again, there is dismissal. Dismissal occurs in two ways, where when you're dismissed with notice, and in another situation, you're dismissed without notice, otherwise popularly known as summary dismissal. We also have dismissals that occur as an event of a redundancy. And we also have the dismissals, the separations that occur because of retirement and or because of death in service. As you can tell in this particular section here, it is highly involuntary, either on the part of the employer or in the part of the employee, because this separation is not natural. And when I mean natural, the employment process is mainly employee-centered, where the employee is the one who is in control of the agreement of how they work, how they perform, and when they leave the organization. And the employer's responsibility also is to enable the employee to negotiate properly, give them an environment where they can perform and thrive, and even when they are exiting, they exit feeling that they have benefited from the employment, and that wherever they are going next is a place where they can be able to, enjoy good relations, good continued relations with their employer. Now, when I say good continued relations with their employer, I really mean it. You can't leave employment and actually have a good relation with your employer. It's not every day where you're supposed to, I don't know which word I'm supposed to use here, where you leave employment and it just becomes a big tussle where there's no good blood between you and your previous employer, or your previous employer is completely angry with you, or you're completely angry with your employer, and it raises you to have very negative energy as you're continuing to the spaces you're going. It also causes some employers to have very undue influence in the places that you're going. So I've always advocated for separation to be as amicable as possible, even in the event of involuntary separation, which is a totally different conversation that we can have on another day, because that's not the focus of today. Let's just go straight into the detail of what it means, which benefits are payable in all of these areas of separation. Please remember again to like and follow us on our socials. That's Twitter, Instagram, Facebook, and YouTube at Conversations with Wendy. And for this purpose, if you have a question, you can always type it on the chat box, or you can type it in the question and answer session, and I'll be able to get to you and answer that question for you. Now, let's go into resignation. Resignation is a very interesting space currently in the labor relations within Kenya. One of the things that I notice and I have to consistently speak to employers about, employment in Kenya is not at will. And employment at will means that one person can, when they want, terminate the agreement of employment. We in this country are very specific about how employment is entered into and how it is terminated. And an employer is not allowed to exercise the right of just giving an employee notice and ending a contract. That doesn't exist on an employer's part. As we continue, we'll speak about the other types of separation, which are involuntary, which are mainly on the employer's part, and I will be able to just highlight some key considerations on how and when an employer can initiate the separation of an employee. In this case of resignation, this is 100% on the employer. So the on the employee. In this case, the employee enters into record and says, hey, I want to resign. And this can be done in several ways, especially depending on which type of contract that you hold with your employer. There are some who are on verbal contracts, so that means that they can just enter a verbal statement. But I don't advise anybody to let people stay on a verbal contract for too long, because the law provides that after a certain period of time, a contract must remain in writing. So when the contract is in writing and it provides that you can resign employment by giving notice of, say, 1 month, 2 months, please initiate it according to the contract. This is when the resignation starts. Now, the resignation should follow the provisions of the employment contract and the labor laws. There are some contracts in employment in Kenya that are written very well, where they provide for you how to resign, which notices to follow, where to send your resignation, among other things. In the event that it is not provided for in your contract or your internal regulations, you can always take reference to the labor laws, which is specifically the Employment Act, where you can notice that if an employment pay period is month on month, the resignation notice should also go month on month. Now, an employer cannot decline the resignation of an employee. I don't know how much I can emphasize on this particular issue because I've been talking about it consistently and considerably. When an employee sends you a resignation notice, at the time they have sent the notice, it immediately starts to count. At the time the notice expires, the employer immediately loses the control they have on the employee as of the last working day. Let me refresh that just for ease of understanding and following. Once an employee has entered a resignation notice according to all the rules and regulations within their contract and the employment contract, that notice starts to count. Whether the employer agrees with the notice or not is completely irrelevant in this particular issue. There is this case that I have listed for you of Edwin Beatty Kipchumba versus National Bank of Kenya, where the courts were very clear. It is a unilateral act when it comes to the employee. And I want to say this again, resignation notice is a unilateral act when it comes to the part of an employee. And there is no part in our laws that provides that the employer must accept the resignation for it to take effect. So again, ladies and gentlemen, please remember, if you're an employer and your employee issues you with a resignation notice, it begins to count. Now, I just need to be able to speak of the time of control between when the notice starts and when the notice ends. When the notice starts, if it is a 1 month notice, during that 1 month of notice so that the employee is still with you, you can be able to continue exercising control of that particular employee. What does this mean? And this is a question that is asked consistently. Like, for instance, if this person is still under a disciplinary case and they decide to resign, you can continue with the disciplinary case up until the last working day of that employee. Many employers in actual fact find that to be tedious and without any benefit. So you'll find that employers will immediately stop such kind of proceedings once an employee has given notice. But you are allowed to continue with that type of process if and when the employee is still under notice. On the other hand, if the employee resigns today and pays you your notice today, you lose control of that employee on that day when they have vitiated the contract. This is because notice is either paid or served from either side. And ladies and gentlemen, also I need to remind you that the employer does have the right to decide to pay you the notice instead of you staying the notice. So that one goes two ways. Another key consideration to remember during a resignation is that irrespective of whether the employee resigned in the way that the organization would have appreciated or otherwise, it is irrelevant to the fact that you must provide them with a certificate of service. This certificate of service is actually something that gets people in a lot of trouble. So I have to be very particular and remind you that throughout the resignation process, as an employer, you must issue the employee with a certificate of service upon their last day of employment. Now, which benefits are payable within this period? We have the notice payment. Like I had stated earlier, the notice payment can be paid or either stayed. So if somebody stays the notice, it means that the notice payment is paid at the end of the notice period. Or if the notice period is longer than the pay process and than the pay cycle, so that if the notice period is 3 months and you pay them on a monthly pay cycle, it means that you have paid them the notice. So it means that they have stayed the notice and you paid them in the normal cycles. But if the notice is 3 months and you decide to pay them immediately, then that notice is considered paid. This is paid. This is what we say you pay in lieu of notice. So this can be exercised by employer and by the employee. Now, they require their salary up to the last working day. Please remember to count that one. So if, for instance, I resign on 20th of January and our payroll period starts maybe at on 31st, let's say, for instance, and I give my notice 20th and I say it ends 20th of February. Now, you will pay the notice. If I stayed from 20th to 20th, that's fine. But when I'm getting my pay at the end of the month, I will get my pay for February, that for January, from January 1 to January 20, and then I get my pay for February for the time that is remaining. Now, you also have to pay all the leave days that this person has earned and has not used. I need to be very specific here. You have to prorate even if somebody has not finished a year of service, because I know there is quite a number of conversation here and there on whether or not we should pay leave if somebody has not finished 1 year of service. The law is very clear on that one through case law, where it says you must prorate the leave, especially after somebody has completed 2 months in service. So remember, if your leave is 21 days, which is the bare minimum, it means that in a month you're getting 1.75. That's a very common use of that particular calculation. So you have to prorate the number of days that they have been there. And then you should pay them any other benefits that are contained in their contracts, their policies, and collective bargaining agreements. Ladies and gentlemen, let me be very clear here. If a person has resigned and in their contract it says that upon resignation, you shall be paid a gratuity payment, pay that payment, whether they served their notice, whether they didn't serve their notice. This is an amount that they are owed that's supposed to be paid. So please keep remembering as you're processing a resignation that other than the notice payments, the leave up to the last working day, the salary up until the last working day, check your manuals, check your collective bargaining agreements instead in the event that you have some, and check your contracts also in the event that you have some, so that you can be able to capture all of the payments and the benefits that are required to be given in the event of a termination of this sort. I see we have 2 questions here, and I'd just like to capture them. Where is there a difference between last day of work and the last day of service? I'm not exactly sure what you're referring to here, but for me, when I mean last day of work, I mean that's the last time they provide you any service. So if my notice ends on the 26th of January, this means I am walking out of the office on this day. That is what I mean by last day, and that would be the last time I will perform the service. I don't know if I've been able to answer your question, but that is the way it is taken. The last day you work is the last day you provide service to an employer. When an employee chooses to pay instead of serving notice, do they pay the employer the gross pay or pay less the statutory deductions? Because you're not the one that actually collects the statutory deduction on behalf of the government, you are supposed to pay the employer that amount, which is a gross amount. So if your payment per day, because Kenya does not operate on net pay, it actually operates on a gross pay basis. So if your gross pay is 21,000 and you're working for the 8 days for the 21,000 and you're paying the notice then would cost you 21,000 shillings. If, for instance, in your organization, there is a formula that has been given through the payroll department on how you calculate your daily pay, you can also go and use that formula and use it towards the days that you have within that month. Now, I see one more that I'll just go with here before we continue. Just give me 1 second. If leave earned is 14 days, for example, but annual leave days in the year are 24 days, do you pay 14 days or 24 days at the separation within a given point? You pay 14 days, because you remember what I've been saying here clearly is that leave is earned first. The payment here is earned, not the one that is given. Like it's a provision. 21 days is a provision. We provide that in the year you will get 21 days. However, you earn them on a monthly basis. And that's why I said you prorate them. By proration, I mean 21 divided by 12. You get 1.75 days. This means that the 1.75 days is the monthly earn that you have. So if you have earned 14 days and not gone on leave within that earning period, what you pay is the 14 days and not the 21 days. Now, in the event an employee has resigned, just a second, in the event the employee has resigned, and the contract stipulates that the employee should serve 1 month notice, but due to some reason, the employer does not want the employee to serve notice, does the company pay the employee 30 days notice and not allowed to serve the notice? Absolutely. Notice can either be paid or stayed, so do not worry about that. If that has been given, you can exercise that as an employer. If an employee calls to let you know that they are unwilling to continue working, is that consideration as resignation, or they must put it in writing? It can be construed as resignation, especially when they say that and they stop attending work. It means that they have in actual fact stopped working for you, so that it can be considered as a resignation. Sometimes you can, I always advise employers when these things happen to put it on an email and have the employee respond and say, does this mean you're resigning? Clarity is very good for you, because sometimes some employees will tell you that and then 3 days later they show up to work. So just make sure that they actually write it down, but depending on how they perform moving forward can be an actual indication that they have resigned. Is a certificate of service issued when the employee hasn't cleared with the company? I want to be quite, I don't know which word to use here. The law does not recognize the fact that an employee has cleared or has not cleared within the organization. There are some things that an employee is supposed to be paid, and it is actually a slippery path there, even when you go to court on some issues. When an employee has given you notice, they have completed the notice and they have left, a certificate of service should be issued by the last day of working. I always advise employers, for purposes of making sure that everything is tidy as they are doing their job, an employee that resigns during the notice period, on the last week, please start your clearance processes so that on the last day that they are leaving, they have completed everything and you can then process them correctly, instead of waiting on the last day of notice, then starting your clearance procedures, because that has actually gotten some employers in trouble, where you notice that the law actually says, for instance, upon summary dismissal, you should pay somebody immediately, and upon general dismissal, you should pay according to the next pay cycle. So you can find that sometimes I refuse to come and clear, and you're holding my money for, let's say, 3 months, and I go to the labor office. That is a coin toss. Sometimes you can win that case and sometimes you cannot. So you have to be, I always call it err on the side of caution, and make sure that these things are prepared before you actually get to the point of resignation. When an employee chooses to pay instead of serving notice, do they pay? Oh, this one we have already answered. So this is all the considerations that we have when it comes to matters resignation and the payments upon resignation. Now let's go to the second type, which is a mutual agreement to end contracts. Now, mutual agreements to end contracts are very interesting. First, this is just a slippery slope on its own. So an employer should be very careful on whether or not they want to exercise this kind of termination of employment. This occurs when the employee and the employer together agree that the employee can leave employment under a certain type of agreement mutually between themselves. The reason why this is recognized is on the simplicity of the fact that you as an employer and an employee can decide amongst yourself that you want to vitiate the contract. Now, here the agreement has to be consented to by both parties. The agreement must be duly signed by both parties, and the terms of the separation should not violate legal principles. I want to bring your attention to the case of David Waithaka versus World Vision International. Sorry, it's supposed to be 2017 on EKLR. What you notice is this situation, the employee was working for this organization, I think in their South Sudan office. When they were in South Sudan, they went on leave, and then the civil war broke. After his leave period, he was supposed to go back to work, and he did not go back to work. He actually said at some point he was sick for 7 days, and then they tried to reach him after the 7 days, and the HR manager was reaching him maybe at 5 p.m., sending him emails and messages, and this guy was not responding. And at the end of it all, they sent him a separation benefits package, where they had proposed you can leave on these terms and asked him to sign it on this particular date. So this employee tried to negotiate with the employer, but then they ended up agreeing that the term stays the same, and he signed the contract as that, and it was considered a mutual agreement to end contract. Ladies and gentlemen, what is exciting about this case is that this individual sued the organization, and the organization actually was found culpable of a constructive dismissal. And a constructive dismissal is just when an employer creates an environment that is so untenable that the only option an employee has is to resign. So you notice what happened here is that this employee, as much as they were given the mutual agreement, as much as they agreed, he claimed that he was completely under duress during that period. He never wanted to sign that contract. He was unwell, that the organization did not recognize that he was unwell, that they didn't recognize that he had a sick period that he was given by a doctor with the proper paperwork, that they continually pushed him past working hours, sending him emails and berating him, and he felt that there's no other option up until I sign this. So again, ladies and gentlemen, you notice how slippery of a slope this is. So I keep advising people to try as much as possible to stay away from this mutual agreement to end contract. But in the event that you cannot, please make sure that the separations do not violate the legal principles. Like in this case of David Waithaka, how the courts construed this was as the employer constructively dismissing them, because now David felt that the only way he could work, could have his own peace, was to resign. But he says he really did not want to resign in actual fact. So be very careful if you're going to use this type of separation, and make sure that you follow each and every agreement that is within the legal principles, and make sure that the contract is signed between the employer and the employee. Now, in this particular type of agreement, the benefits that are payable upon its execution are highly dependent on what is in that contract. So you have to be guided by whatever is contained in that contract. Now, I see a question here that asks, what would you advise being reasonable amount of time within which a resigned employee can rescind the resignation and it becomes acceptable by the employer? For me, as long as the employee has not left the organization, and if the employer is still willing to listen, I think that is quite okay, that they can rescind it at any given time. As an employee, what would be the best approach in addressing employer on constructive dismissal? 9 out of 10, the reason why constructive dismissal was actually eventually recognized by law was because the employee in this case is very powerless. They are very powerless to act. There is nothing much that they can be able to do because the employer here holds all the power. In the event that this is happening to you, the best I can advise you is to go to a labor officer, for the labor officer to come and visit the employer and have negotiations with them. If this has already happened to you and you have already resigned, you have the legal mechanisms where you can go to court and institute suits. I also advise employees, for their own well-being, when you can tell that an employer is trying to constructively dismiss you, I prefer that you create your own boundaries for your own well-being and safety, and just start to look for something else. But the thing that is available to you is that you can be able to go to the Ministry of Labor and bring in a labor officer, or if it has already reached the point where the resignation has already occurred, you still have the mechanisms to go and sue for unfair termination. Now, the other questions that are here, I'll answer them later, except should mutual agreements follow previous precedents on benefits payable? I would advise yes. If there is a mutual agreement that occurs and there is precedence on how the company treats these kinds of agreements, then you should follow that. Because then if you don't, a person can easily say that you discriminated upon them. So if there is a precedent that occurs in this particular issue, the right way is to follow the precedent. However, mutual agreements, again, very slippery slope, because it is highly dependent on how the person and their employer come to an agreement to end the contract. So again, please notice that this is a very slippery slope, is not advisable to use. However, if you're in a spot where you need to do this, those are the best ways to deal with it. Now, the next type of separation are those ones now in the zone where the employee does not have the power to work with it. And the first one is a fraction of time. I like using the word a fraction of time because quite a number of people say it and it looks like something really big, but it actually just means your contract has come to an end. Now, one of the things that you need to consistently recognize is that when you've given somebody a term contract and you know that it is ending, say, on 31st of March or 30th of March 2023, right? And it is now February. The good practice is to issue a non-renewal notice before the actual end of the contract. One of the things that people don't recognize sometimes is that the courts recognize the employee's ability to be comfortable, to plan, and all of these things. When you don't issue a non-renewal notice, sometimes it can be taken as a legitimate claim to expect a renewal. And this was actually seen in the case of Johnston Luvisia versus Allpack Industry Limited, where the judge held that the failure to issue a non-renewal notice up until the expiry of his contract, I mean, they just waited until the contract expired. So they were awarded 3 months of pay to cater for the inconvenience of finding himself without a job unexpectedly. The judge found the behavior untidy to failing to manage the claimant's legitimate expectation, even though the employment contract did not require for it to have an non-renewal notice. Ladies and gentlemen, if you listened very closely in 2021, the Court of Appeal did indeed stick to this particular issue on the case of Kin Cleaners Limited versus Kenya Plantation and Agricultural Workers. There were many other issues that occurred here, but one of the things that was said was the failure to issue a non-renewal notice is one of the things that became really clear to the courts that there was a legitimate expectation from the employee to get their contract extended. Now, when a contract ends on the 21st of January, please make sure you end it on the 21st of January to avoid legal exposure. Now, the legal exposure here becomes you forget to end the contract on the 21st of January, and the contract said it ends on the 25th of January. Then you end it maybe on the 30th of June and say, you know what, your contract had expired. What happens here is that when a contract that has a term date ends and you continue performing the contract, it immediately becomes renewed by conduct, which means that it can either be renewed as a month-on-month contract, or sometimes you can argue that it is renewed to the same period as the previous one, and then it goes like that. And in the case of Benson Odhiambo, the fixed term contract ended, and the company did not renew it up until 9 months. Then after the 9 months had lapsed, they went to end the contract, and the courts held very clearly that that contract was renewed as a month-on-month process, and therefore it had to be dealt with in terms of ending it with the law, with the proper processes of the law, meaning they had to end it with just cause. Now, ensure that your staff on contract are not doing continuous jobs to avoid, again, legal exposure. And this is one of the landmark cases that we have right now, where Kin Cleaners Limited versus Kenya Plantation Workers Union. Here, what happened is the people had their contracts renewed severally. And then at some point in the, maybe I think it was the third or fourth renewal, it was automatically ended because of the term of the contract. And these people sued, and they say they had a legitimate expectation that their contract will be extended. And the courts found that indeed it is true that the expectation to have their contract extended was legitimate, and that the job they were doing was obviously that of a continuous job, and that the failure for the employer to issue a non-renewal notice made these employees reasonably expect that their contract will be renewed. So ladies and gentlemen, again, when you're dealing with these types of contracts, please make sure that you issue a non-renewal notice, make sure that you end it on the day of termination. And when you have the habit of continually renewing the contract, you're better off giving somebody an open-ended contract. Again, in this particular situation, a certificate of service must be provided. And the benefits that are payable here upon the fraction of time is the salary up until the last working days, the earned but unused leave days, those are the compulsory ones. And then if you have any other benefits that are contained in the contract, policies, and collective bargain agreements. So ladies and gentlemen, here is where if you have gratuity, it is paid in this particular point. If you have any other types of payments that you have stated in your contract, they are paid at this particular point. So be very keen to make sure that as much as you are paying the contract as per law, look into your benefits contained in your policies, your contracts, and collective bargaining agreements. So then I'll take here some questions that we have. At what point should the notice of non-renewal be given? 2 weeks or a month prior? For me, I find it easy when you give the notice according to the pay cycle. So if you pay after every month, please give a 1 month notice. If you're paying after every 2 weeks, please give a 2 week notice so that somebody is aware that in the next pay cycle, you're not going to be receiving a pay. Now, when it comes to what is the best grace notice period for an non-renewal, like I said, consider it on your pay cycle. How do we handle staff loans? Staff loans is a type of deduction allowable on pay, and that one goes with the 1/3 rule, where it says that you're not supposed to deduct more than 1/3 of an employee's salary in any given pay period. Now, what would you advise as being a reasonable amount of time? This one we've answered. Should that's we've answered. Should the employer deduct loan like HELB or any other form of employee at the time of calculating final dues for the last month of service? Absolutely, because these are statutory, these are deductions that are allowable. What is the best grace period? This we've answered. If you fail to give an non-renewal notice, can you pay 1 month in lieu of notice? Again, that's a slippery slope. I wouldn't advise you to do that. You're better off just going with your chances, but you can do that for purposes of humanitarian appreciation and understanding. At what point should the notice? This one we've answered. What is this we can term as continuous jobs? Please elaborate. Let me give you an example. When you have an accountant on contract, and they stay on contract as an accountant for 16 years. You're always issuing them 2-year contracts, 2-year contracts, and then you issue them your 8 contracts, and then on the 9th contract, you terminate it because of end of time. That is a consistent job, and the courts will hold us that. So please make sure that when somebody is doing a job where the legitimate expectation that the job will continue has been followed and adhered to. Should notice be given if a fixed term contract spells out that the contract should be terminated? Yes, that's what the courts held. And I've given you 2 cases where we have John Luvisia versus Allpack 2019. But the bigger cases to follow is the Keen Clean Limited versus Kenya Plantation Agricultural Workers Union, because this matter went up till the apex court. This is the Court of Appeal. And the Court of Appeal actually said that the failure to issue an non-renewal notice does in actual fact create a legitimate expectation of renewal. Should the issue of notice be done in writing? Absolutely. Is the end of contract date sufficient to end the contract, or notice is required from the same? Like I said, courts are now ruling that issuing this is required. Regarding the non-renewal of contracts for continuous job, how should the employer handle this? If you have an employee that is working continuously, just give them an open contract. It works much better than what it is that employers do. Is the deduction of 1/3 or 2/3? Please specify. What it means is that 1/3 is the amount the employer should remain with, the employee should remain with, and the maximum deduction should be 2/3. Is it legal to hold final dues if the employee hasn't returned company property, or how would you best handle this? You're supposed to pay this, because again, we have said the maximum deductions that you can make are 2/3. The 1/3 has to go to the employee. And you notice that the labor laws in the Employment Act actually say that on summary dismissal, you should pay upon the last day of working, and that on matters normal dismissal, pay within the next cycle. What happens? Is it legal? Okay, force majeure clauses is it applicable in contract termination? Is the notice mandatory? When you say force majeure, when it comes to unemployment, then this is issues that are dealt with mainly with through redundancy processes. Because even if an employer is declaring to be insolvent, or maybe there is a huge thing that occurred, say, like you're saying, force majeure, earthquakes, etc., and other acts of God. Here, there is another totally different process on how you deal with employees, because they then become people that are secure debtors towards that particular legal person. What happens if the contract ends and not renewed on time? Is it allowed to go back on the date? No, when a contract ends and you continue to perform it, it becomes renewable on a month-on-month basis. And I've given you a case here, Benson Odhiambo Onyango versus Insurrect Company Limited. This is exactly what happened, and it was answered in that particular way. What guides the number of days to issue? That one we have already answered. If an employee has been on a one-year contract for 3 years, can you issue a notice of non-renewal on the third? Yes, you can issue, but you can easily fail to get away with the fact that this is considered a continuous job. Can I use my leave days as the 1 month's notice? Absolutely, yes. Please let me know of a case of a senior business development who committed to deliver sales on time of employment and 6 months sales were not done despite weekly. Is it right to terminate since he can indicate? Now, this is a type of termination of employment, and an issue that is not being dealt with in this particular webinar. But what I will advise you is that you can terminate for performance reason, and there is a process through which you go through for termination. In that case, you issue a show cause, they respond, they come into a disciplinary process, etc., and it goes that way. Now, when a company is insolvent, is it mandatory to inform the labor office? Yes, actually, that is required according to our labor laws. Now, ladies and gentlemen, allow me, for the purposes of time, to also move to the next part of the separations, and this is dismissal with notice and or summary dismissal. Now, this is where I speak about the proper processes of dismissals have to come into play. And this is now one, the reason should be valid. It should be fair and in accordance with a fair procedure. That is what our law says. So valid reasons have been provided for in our Employment Act. Please check them to make sure that you're not dismissing somebody for a reason that is not valid. The termination, the fair in the sense that there are some things that are considered unfair when it comes to dismissals, like it's unfair to dismiss somebody on discriminatory basis, maybe because they were pregnant, and among other things. These are also provided for in the law. And then there is a process that is considered a fair process and standard that has been used time immemorial, which is the employer gives a show cause, the employee responds to the show cause. From the show cause, the employer invites the employee for a disciplinary hearing. During the disciplinary hearing, an employee is allowed to have a person who witnesses the fairness or otherwise of a procedure. After the disciplinary process is finished, the meeting is finished, you issue minutes where everybody signs their minutes. Then you go into the process of giving the person the outcome of the disciplinary hearing. The person has a right to appeal or otherwise, and if they don't appeal or otherwise, you process them out. So you can have gone through this process of separation and you notice that the reason falls under those in section 44 of the Employment Act, which constitutes summary dismissal. So with summary dismissal, it means you're paying them you're dismissing them without any notice. And then there is the other dismissal where you're dismissing them with notice, but then you are going to pay the other benefits that come with it. Even in this particular case, even when the employee, for instance, has robbed the company or has put the company in disrepute, you are still supposed to give them a certificate of service. I cannot overemphasize this point, ladies and gentlemen. You must consistently give the certificate of service to an employee, irrespective of which type of separation process they went through. Now, the benefits payable upon resignation are notice, as is contained in the policies, your contracts, your collective bargaining agreement, but this is not applicable in situations of summary dismissal. Your salary up till the last working day, and but unused leave dates up to the last working day, and any other benefits contained in the policies. Now, please note, again, with leave, when they are serving notice or otherwise, they are earning leave. When you are dismissing with notice, if you dismiss with 1 month notice and my leave days were 10, the leave pay should be 11.75, because I said if you're going to be giving a minimum of 21 days, divide by 12, it's 1.75 days in a month. So that means that I also earn leave during the time of the notice payment. So please remember that as you're dealing with this particular type of situation. Now, looking at some of the questions we have here is, what exactly is an open contract? In the event an employer wants to end a contract, how does that happen for open contracts? So the open contracts are the ones that do not have a term. And when a contract does not have a term, this means that it is sometimes permanent and pensionable. Please note that when I say sometimes permanent and pensionable, there is people who have open contracts but don't pay pension, which is quite okay, which means it doesn't have an end date. So an open contract doesn't necessarily mean that it is permanent and pensionable. Sometimes it can just not have an end date, and in some cases it can have an end date. And when you have this type of contract, you have to end it for a valid reason that is not unfair and is in accordance with fair procedures. That is exactly how the matter should be handled. Let me just look through to see your questions. Can an employee take the remaining leave days so that you don't pay them if you're terminating their contract? Yes, they can take their leave days, meaning that if I have, say, 25 days of leave and I resign, I can actually go on leave and my notice is 30 days. I can work up until the 5th day of the month and then leave for my 25 days, and I will get my payment at the end of the month without an extra 1 month. But please, ladies and gentlemen, be aware that that 25 days of leave is payable because they earned them. They are doing you the favor of not deducting that from their terminal dues, so that you don't say you owe me this number of notice pay. No, you leave them, they go on notice, and you pay them up until the 5th. Please clarify on summary dismissal on computation of leave days payable. Now, when somebody has left for summary dismissal, it means they leave on that particular day that the decision is issued. If at that particular day they had 90 days of leave, they are supposed to be paid 90 days of leave. That's just what I mean. It doesn't mean that what I should clarify maybe is if they were supposed to earn 3 more days within that year where they were terminated, you're not supposed to pay 93, you only pay 90 because at the time they were leaving, they had 90 days of leave. Now, suppose the staff is issued with a show cause for theft and his reply, he agrees to the allegation. Must HR conduct a hearing as a matter of procedure, or can HR proceed and dismiss such a staff? Kindly please proceed with the hearing, because again, there's many cases that have ruled very clearly that the failure to follow a process, irrespective of the fact that the reason was valid, does constitute unfair termination as looked at in Section 45 of the Employment Act. So make sure that you're always getting the reason and following up to ensure that the process has been done correctly. There's somebody here who has asked us a question that is slightly off topic, which says, what are the factors to consider in an employment contract as a consultant for a period of 2 years? My word, that is a big question. I want to refer you to a webinar that we did on our YouTube page that has a lot of details to do with consultants and employees, and you will find a lot of information there that will be useful. Kindly repeat on employee taking leave during notice as payment of final dues. So if I don't want to stay for the whole month, right? Like let's say, for instance, I have 25 days of leave and I'm supposed to give you 30 days. So I work up until day 5 and then I take leave up until my last day. So that means that the employer owes me up till the 5th. They are supposed to pay me, and what I owed them for the remaining of the 25 days, I've substituted it with my leave. This is what we call in lieu of notice. So I give you my leave instead of giving you the notice period, which is allowable. What is the legal position on forfeiture of leave? Does payment of accrued leave of a period of 18 months going back to apply? One of the things that I'd like to tell you here is that the Kenyan law does not at any given point recognize the forfeiture of leave as a process. The courts have held this very significantly. they normally consistently ask that you continuously ensure that you provide a situation where an employee can go on leave. What the law says is, yes, after 18 months from the year that those leaves were taken. So this is what you need to recognize. If you're talking about the 18 months and my leave is for 2023, I mean 18 months from 2023, not 2023 and then an extra, I think 12 months that comes, not 12, I miss my mathematics there, and an extra month that make it 18. Is my leave period is 2023, and then an 18 months, which you notice is a very stretched period. So please be very careful when you are making people forfeit leave, especially when you have given only 21 days of leave. Because the law actually says that people who give extra than the 21 days can agree amongst themselves on how to use this leave. But also the courts have been very, very sticky on not allowing for leave forfeiture to be paid, to occur. Okay, then we see, can final dues be paid via online bank transfer? I have seen a company that insists on doing physical checks. This is actually quite okay. You can pay them online as long as you provide them with a payslip. Great reminders. The rule of thumb for termination of employment pass. Thank you very much for that. We really appreciate. Can we forfeit employee leave days balance at the point of renewing contract? Absolutely not. That is illegal. You cannot do that. If a fixed term contract, but for continuous jobs, and the contract has clause stipulating that the contract ends as stated, will you still have to give notice? Will you have to give cause for non-renewal? Can the concern on legitimate expectation arise? Yes, because one of the things you have actually just said is that it is for a continuous job. So obviously there is a legitimate claim there that they are expecting renewal. One of the mitigating factors is you can immediately before the end of the first contract give them a notice of non-renewal. You can get away with that very quickly. But if you renew the contract 5 times, and then it is on the 6th time that you want to end it, there is 9 out of 10 a legitimate expectation for renewal can arise. Can an employer give an employee garden leave while serving their notice period? Absolutely, that is upon you and your employer. The last question I'll take, do you mean leave earned in January 2023 can only be forfeited by July 2024? Actually, I mean longer. It is 18 months from the year of earning the leave that is occurred. So please go and read the provision. I think it is 17. Let me not give you the actual place in law, but it is on the provision of the leave itself. It does say 18 months from the leave earning period. So please, again, recognize that courts are very sticky on the fact that leave should not be forfeited. So work around that particular situation to ensure that instead of forfeiting leave, you are going outside of your way to make sure that you're providing an environment where employees can actually go on leave. Now let's go to matters redundancy. When it comes to redundancy, consider that the reason for redundancy must be in accordance with Section 40 of the Employment Act. Please go back again to the webinar we did on redundancy. It's available on YouTube to go through the processes and the procedures of redundancy. You could also go to our website, www.conversationswithwandy.org. On the area for tools and samples, we have provided you with a toolkit that goes through the process of redundancy that will capture these key considerations very well for you. Again, you have to make sure that the selection criteria is in line with Section 40C of the Employment Act, and that where there is a CBA, this is a collective bargaining agreement, ensure that its provisions are followed. If its provisions are not followed, this redundancy can be vitiated. And also in this space, a certificate of service must absolutely be issued. Now, the benefits payable upon declaration of a redundancy, a severance pay at the rate of not less than 15 days for every year. Please, I said not less than 15 days for every year of service. I didn't say that it cannot be more, is that is the legal minimum, 15 days for every year of service. There is a 1 month notice pay that can either be paid or stayed. Then there is a salary up until the last working days, of course, your earned leave and any other benefits contained in your policies, contracts, and collective bargaining agreements. Now, I see here a question: what happens at termination when the employee owes the organization more than their final dues? You have to figure out other mechanisms to get recovery, because it is not proper for you to give an employee zero amounts of money. The quickest way to work around this is to get an agreement with the employee for them to be able to reimburse the company a certain type of payment that is there. But withholding their payment, has time without number been considered not proper? So make sure that you go out of your way to create other mechanisms of recovery other than using the pay slip. One of them could be an agreement between the employer and the employee that they have agreed to use these amounts that they have to pay off any debts that they owe the organization. Is an employee entitled to leave if he has worked only for 9 months? That's inclusive of probation. Then he terminates due to lack of business opportunity. Yes, like I said, leave should be prorated. It's very clear. It's clear in law. The case law is very specific on this one. You have to prorate the leave days according to the number of months that they stayed in. So that's why I kept saying, if you have 21 days as your leave provision for the whole year, and I have stayed for say 5 days, each month I have earned 1.75 days. When I leave, you should pay me the aggregate of this 1.75 days. So you must, at every given point, prorate leave days, even when they are still under probation and irrespective of the reason that they have left the organization. Now, when it comes to retirement, retirement is a very interesting space for me. What I notice is that very many Kenyans, especially in the private sector, are unaware that there is no provision in law that gives the minimum age of retirement. What has happened is that we have been informed a lot by public policy, especially for the people that are here who work in the public sector. They are the ones who have put a minimum age of retirement at 60 years. But also there are some companies that follow this process, and it's also best practice within case laws, where it says that the age of retirement should be 60. In fact, there is a case, it's called Kenya Plantation and Agricultural Workers Union versus Unilever Tea, where the court had actually ruled before that there is no mandatory age of requirement in law, and that people can be able to do what it is that they want. Sorry, I mean James Kabengi Mugo versus Syngenta Africa. That's the case that actually said there is no such thing unless it is contained in the employee handbooks, unless it is contained in the CBAs or any other policies that you have internally in the organization. But then this case of Kenya Plantation and Agricultural Union versus Unilever Tea, this is where the court had ruled that the mandatory age for retirement for the unionizable employees will be 60 years with an option of retire at 55 years, because that is what was contained in their contracts, in their CBAs, and as advised by public policy and best practice, it goes with 60 years. Like I said, early retirement is allowable from 55 years, while the minimum age actually varies in different sectors. Like people with disabilities, their minimum age for retirement is 65 years, the same for judges, and there are other types of employments that actually follow this principle. Again, a good employer, I always advise, should have a retirement policy. If you don't have a retirement policy currently, please work to create one. And even in retirement, you should be able to issue a certificate of service. When it comes to the benefits that are payable upon retirement, these are consistently what is contained in a contract. And the last one is the total pension benefits. If you're giving a pension, please give the total pension benefits for the employee to decide if they're going to do a total withdrawal or they're going to buy an annuity, etc. Then that becomes their issue. Please remember that the law does not provide for what you should pay somebody after they have retired. It doesn't provide for that. So it just goes back to, you pay them up until the last working days, the leave days that they have earned. That is the legal minimum that is required. However, if you have in your contract of employment better provisions, you can always use that one. If you have in your retirement policy better provisions, you can always use that one. And please make sure if you're issuing any pension at this particular point, you need to be able to give the employee the option of withdrawing their total pension benefits. This means the employer contribution and the employee contribution. They themselves can agree amongst themselves on whether or not they will buy an annuity or do a total withdrawal. That is absolutely for them to agree, and it has nothing whatsoever to do with the employer. What is the process for retirement? What are you supposed to do? For me here, I'd say there is no recognized process of retirement by law. But by good practice, you notice that quite a number of employers have a retirement policy where they give a notice to retire to an employee that is about of age 6 months before they hit the retirement age. So once this notice has been given, there are some preparations that are normally put in place to ensure that this employee is well prepared for their retirement. Some organizations go out of their way to start teaching how you can live past retirement, how to manage your money within the time of retirement, your health, your total well-being is put into place. Some employers are actually quite proactive in this particular situation, where they actually start having conversations with employees past the age of 40 on how to plan for retire, how to save for retirement, and how to handle yourself after you have retired. I don't know if anybody here is familiar with Bitangen Demo, who said that when he stopped work at some point, his phone stopped ringing completely. He actually thought something was wrong with his phone. And when you look at records, cases of how long actively employed employees normally stay alive after the period of retire, you notice that actually the life cycle there is quite small after the retirement period. This is why employers are requested kindly to continuously start preparing employees for retire before the retirement age actually comes. Talk to them on how they can manage themselves, use their time, spend their money, among all these other things. But there is no provision in law that exists on how you should do this. So you can actually just go and look at what is best practice and what works for you, and then you implement that. Now, on some questions that are here is on pension withdrawal, please confirm if RBA only allows one to access 50% employer contribution unless you are the age of 50. This has changed recently, and yes, before you could get 100% of the employer contribution when you resign, but now it is 50%, so that's the case. But this is not the case for the people who have attained the age of retire. What happens if the final dues are less than the outstanding loan when an employee is obliged to transfer final dues to a financial institution or bank, what percent should be paid to the staff, or all of it goes to the financier? I always tell employers to really desist from signing that part of the loan thing. What I've seen is quite a number of employers, instead of signing that, they will go out of their way and issue just a letter that says so-and-so is employed, they're not under any notice to resign, and they have given us instructions to pay their salary through this bank. End of story. Because again, that is a very slippery slope. The law recognizes deductions that are allowable up to a maximum of 2/3 of their salary. The rest is not recognizable within the law unless there is an actual agreement. And what happens here, employees sometimes sign this agreement where they say, yes, I have agreed, you transfer to the financier. And then they go back and say, actually, I was under duress completely and I did not want to do this. And my employer is acting on this because they have power over me. Again, remember even the case that I have spoken to you about earlier on the case of the gentleman for World Vision. He agreed, but then said he was under duress. So if you can be able to avoid signing such kinds of clauses for bank loans, the better. What I know that works in many institutions and is best practice is to issue a standard bank letter to the bank as an employee. And quite a number of banks in Kenya actually allow that letter to work and serve sufficiently. This is simply because what is recognized as the allowable deduction is up to a maximum of 2/3 of their pay. After that, the pay has to go to the employee. That's what the law says. Is there a law on contract break where managing employees on fixed term contract? I'm not sure I understand that question. I would request for you to just ask it again so that I can appreciate it better. What are payables when a staff writes a retirement letter and he's employed on contract and issues a month's notice? Again, like I have told you, there is no actual law that says this is how you should handle people on retire when they are retiring. But if you have a retirement policy within your organization, you should follow what the retirement policy of your organization says. And it is actually best practice for you to have a retirement policy within the organization. So in this particular situation, just go back to your manuals and follow what the manual says in terms of retire. Sorry, did you say the law requires you to give a 6 months notice of retirement for an employee? I did not say that. I said this can be part of your retirement policy. There is no law again that says that you should do this and this and this during retire. It is good practice to have a policy. What I have seen in many policies that exist for retirement is that a retirement notice is issued 6 months before the age of retire to allow the person to plan and organize themselves. Again, ladies and gentlemen, this is not law. This is good practice, and it is highly guided by what works for you. So you can actually just have in your contracts and your policies absolutely no provisions for retire. And when the person reaches the age, you just tell them starting next week, you have reached the age of 60 and we are retiring you. That's totally fine. But again, you have to recognize that you have to be an attractive employer. You have to be an employer that values and cares for the people that work for them. So having a policy rather than just shocking somebody with retire is much, much better. If I want to leave an organization, can I give early retirement letter when I'm at the age of 40 rather than writing a resignation letter? Early retirement is only recognized from the age of 55 going forward. At 40, you actually have to resign because it's highly unlikely that there is any organization that will accept retirement earlier than 55. And the courts have been very, very clear on the fact that the earliest allowable time for retire is 55 years. However, there are situations where employers and employees agree on what they call the voluntary early retirement packages. Again, that is a mutually agreeable conversation between an employer and an employee. And if you have one, you follow there. What happens to the other 50% of pension? It remains in a recognized pension fund until you're able to reach the age of retirement. Then you can be able to withdraw. Can you send somebody on early retirement at age of 55? This has to be done in agreement. You just cannot force somebody to retire before they reach the actual age of retire. So please remember here, you have to have agreed with somebody before that actually happens. I'll take 2 more questions in the interest of time, and then we continue. Clarification on the contract break. Is there a provision in law to allow for a period of separation between 3 to 30 days prior to re-engagement of a contract of an employee? That is, you can do it, but that is a tricky way for you to make sure that that person does not have a continuous contract. This normally happens, especially with those people who have hired people as casual workers, and then they don't want to convert their contracts into proper employment. So what they do on day 90 is that they end the contract for 3 months or 30 days, then they start it again. It's not illegal, but it is not fair. And for people that follow conversations with Wendy and employers and employees in this area, I always advise that we do that which is right, that which is fair, and that which is proper, so that we can continue having an employee of people who are healthy, they're happy, they're creative, and they're at their best. Yeah. So it's not illegal, but as a listener of Conversations with Wendy, please go on the other direction. If it is an open contract, just give an open contract. Can an employee on a continuous fixed term contract claim discrimination for not having company pension scheme, which is only for open-ended contracts by companies? Not necessarily, unless there is other reasons as to why they would want to claim such a benefit. Is the company policy on retirement, if the company policy on retirement is 57 years, is this compliant by the legal retirement age? What is the reference for the legal retirement age? 57 is not the minimum age of retire. The minimum age of retire in Kenya is normally stated in the public sector, where it says 60 years is the age of retire. Now, there are cases that I have spoken about that have actually said that the minimum age for retirement is 60. There is the case of James Kabengi Mugo versus Syngenta East Africa Limited, Kenya Plantation and Agricultural Workers Union versus Unilever Limited, that have gone again and said that this is indeed the minimum age of retire as 60 years. So with 57, I think you're going to be in a lot of trouble because that is not considered best practice and it is not actually substantiated by any case law that exists. But best practice is looked at as 60 years, which is mainly adopted from public policy and the people who have been employed in the government and public sector, and also case law supports 60 years. Can we train employees and bond them for a certain period? Yes, you can, but be very clear to issue the bond in ways that are contractually allowable. This is a totally separate conversation on its own that we shall have if you continue to follow us on our webinars monthly. Can you issue renewable 1-month contracts to employees? Please don't do that. You can, but I advise you not to do that because again, it's not fair. It's not the right thing to do. If somebody is going to be working for you for 6 months, just give them a 6-month contract for their own peace of mind. But if you continually issue a 1-month contract and you're issuing consistently, like I had spoken about earlier, you do run the legal risk of somebody suing you for the purpose that they had a legitimate claim of expectation for you to renew that contract. So again, be very careful when you're in that space because it is, in actual fact, a very slippery slope. Sorry, let's go back to the last one, which is death in service. So when death in service occurs, which is normally a very unfortunate state here, an employer is required to provide a notification to the Ministry of Labor. So the local labor office around you, within 7 days, please give a notification of the unfortunate passing of your team member, and ensure that as a practice, employees nominate legal representatives that can actually receive benefits in this case. And when I mean legal representative, ladies and gentlemen, please tell your employees to be very serious about this issue. Don't be casual about it because it can actually happen and you might find yourself in very, very strange positions. So be careful on who it is that you nominate in your paperwork, even if you're young. You know, sometimes we think we are very young and we don't foresee anything happening to us. So sometimes you write your girlfriend that you end up breaking up with, and then you know you're in this weird space if such a thing happens to you. So make sure you're putting people that can actually benefit from the benefits that you have in the event of your unfortunate demise when you're in service. Such people can include your legal spouse, can include your legal children, and the people that are highly dependent on your pay as you're moving forward. And in the event of a dispute with the legal representative, like for instance, I have put my child and another child appears that can be able to prove that they are my child and they should benefit from this particular type of payment. What normally happens is if the dispute lasts for more than 3 months, the employer is required to go to the labor office and deposit that amount there that then will be taken into the courts for purposes of succession, because the employer is not at any given point allowed to get into matters succession. So you just hold it. If it passes 3 months while you're holding, take it to the labor office so that it can be taken through to the succession processes. So again, here we pay the salary up to the last working days, the leave days that have been earned but have not been used, and any other benefits that are allowable in collective bargaining agreements and all the other things. I see here a comment that says, I really like the pocket guide that you wrote in April 2021 on labor laws. Please, the updated one with me, if you have, I will be able to share. We do have this, and we actually do run quarterly cohorts on labor laws training. You can always just write to info@conversationswithwandy.org, and we can be able to get in touch with to join you in one of the next cohorts that exists. Now, I wouldn't complete this discussion without going through one of the most controversial things that occur, and I am not sure why. And I just want to be able to explain this one more time so that staff can consistently understand what this is, and that employers can also consistently understand what this is and know when what arises and what does not arise. Now, service pay. The law does say that an employee that resigns should be paid service pay for every year of service. That is in law. However, we fail to read what is immediately after, which says this amount is not payable if, number one, an employer is not a member of a registered pension or a provident fund. So if your employer does not have a provident fund and does not have a pension fund, then they are supposed to pay you service pay. If in your contract, the employer does not have a pension fund or a provident fund and does not have a statement of gratuity in their contract, then they should pay you service pay. And if your employer is not registered with NSSF, they don't have a gratuity scheme, and they are not a member of any pension or provident fund, they should pay you a gratuity pay. What I'm trying to say here is that it is highly unlikely within the Kenyan system for any employer to be required to pay service pay, because number one, they are already members of NSSF, because that is considered mandatory for all employment. You also notice that quite a number of employers do have a gratuity scheme or are members of further pension or provident funds. I also need to say, ladies and gentlemen, that the calculation of service pay is left to agreement between the employer and the employee. There is no point in law that actually says this is the calculation of service pay. It only says it should be payable after resignation for every year worked in the circumstances that follow. So you notice that NSSF technically knocks out any other person that is within this system that needs to be able to pay service pay. Excuse me. Now, when we come to severance pay is only payable during a redundancy. If a redundancy has not occurred, ladies and gentlemen, severance pay does not come into play. The minimum amount payable is 15 days for each year of service. So for every year of service, you pay 15 days. The law says for every completed year of service, but what I have seen consistently is that courts are ruling that you prorate for the service years that are not completed. Gratuity. Gratuity is at the discretion of the employer. In fact, the word gratuity means that it is a gift. It is not a legal requirement, it is a gift that is given. So this is only payable where it is provided for in internal policies and or in CBAs. So ladies and gentlemen, please remember, service pay, there is things that you start checking off. Do you have NSSF? Do you have gratuity in your contract? Are you a member of a pension scheme or a registered provident fund? If any of those answers is yes, you are not supposed to pay. If all of these answers is no, then you pay service pay. When it comes to severance pay, if you have not declared a redundancy, you're not supposed to pay it. When it comes to gratuity, it is only payable if it is provided for in internal policies. One last thing about service pay is that there are some employers who have provided for service pay in their policy. If this has happened, then you should pay service pay according to the provisions that you have put in your policy, because remember, service pay does not have a calculation towards it. Now, is it possible to have a sample retirement policy? We can actually work on that and put it up on our website, www.conversationswithwandy.org. I can put it up as a toolkit for you sometime later within the year. Is an employee who resigns from work entitled to gratuities or service pay? Again, it goes back to what is in your contract. If your contract says that somebody who retires gets gratuity, then you pay them. If it says somebody who who resigns gets service pay, then you pay them. If it doesn't say that in the contract or in this collective bargaining agreement or in any other internal policy, you are under absolutely no obligation to make any of those payments. Now, I see 2 more questions here. In cases of death, instead of the labor office, can the amount be given to the lawyer instead? What is the best practice? Do not give any amounts to any lawyers. They don't have legal standing with you. So do not give any amount to any lawyers, because a contract was between you and the deceased. The lawyer has nothing to do with it, and do not give any money to any lawyer at any given point. The best practice, as dictated by law, is you deposit the amount to the Ministry of Labor, and these people will take it to the courts for purposes of succession, because then they will be held in other legal mechanisms. If you give this amount to the lawyer, it is tantamount to you having given this amount to a stranger. So do not do that at any given point, irrespective of how nicely the lawyer asks you. How is severance pay calculated if employees started with a term contract and later converted to an open-ended contract? The truth of the matter is that if they were in service, those years are considered serviceable. So if they started in June 2021, all of those years are considered serviceable. Please don't use that you ended, then we stopped, unless there was an actual stop in employment. Let's say I worked for 1 year, I quit, or my contract ended, then I didn't have a contract for another 3 months, then I got a contract, then you start from the next contract of 3 months. But if I had a 1 year contract, it ended, you renewed me with another year, it ended, then you gave me another one immediately for open, you count my 2 years, because that is continuous employment. And it is calculated at the rate of 15 days for every year of service. We advise that you prorate, because the courts recently have been asking that the proration should occur. And if you have a better provision within your manuals and internal policies or CBAs, you can always use that particular enhanced provision. Is gratuity given at the rate of 15 working days, and is it only considered after 5 years of service or even less than 5 years? Again, as I have said, gratuity is a gift that the employer gives to the employees. If gratuity has not been provided for in your internal policies, in the CBAs that you have, or in your contract, there is no employer that is under any obligation whatsoever to pay you a gratuity payment. If there is a provision of gratuity in your internal policies or your collective bargaining agreements or your contracts, please go to the terms of your contracts and see what it states. So in this case, if it is said it is calculated in 15 days for every year of service, and it's only considered after 5 years, then that is exactly how that gratuitous payment will be handled. So there is no legal principle whatsoever that works with gratuity. It is a gift that the employer gives according to how they have decided to give it, which should be written in your contracts or your internal policies or in the collective bargaining agreements that exist. I have another question here that says 15 days for every year worked using the current pay or using the pay during the past years. What is normally practiced is that you use the current pay. So if I started earning, say, 20,000 when it started, and then I have worked for you 15 years and now I earn 60,000, you calculate with 60,000. You don't go that on year 1 it was 20,000, on year 2 it was 25, on year 3 it was 40, and then on year 4 it was 60. You go with the current pay that exists within your policy as it stands. Ladies and gentlemen, we have 4 minutes to the top of the hour, and I want to thank you very much for all the questions that you have asked, for your participation. We've been quite a number today in this conversation. I really do appreciate it. It would not have been the same if it were not for you. And should there be no other questions, allow me to wish you a very lovely weekend going forward, and remind you to continuously like and follow us on our socials, which is Instagram, Facebook, LinkedIn, and Twitter. Also, we're on YouTube at Conversations with Wandi. We also have a website, www.conversationswithwandi.org, that has quite a wealth of information for you that you can be able to use as you continue. And as usual, let's meet next on the last Friday of next month, same time, same place, where we shall be talking about the next topic. So once again, thank you very much and lovely weekend ahead.